Law of negligence. Negligence occurs where one person owes a duty of care to another. Examples are one road user to another, a doctor to a patient, an employer to an employee. In Lievre v. Gould, 1893, 1 QBD 491, Lord Esher stated that the question of liability for negligence cannot arise at all until it has been established that the man who has been negligent owed some duty to the person who seeks to make him liable for his negligence. A man is entitled to be as negligent as he pleases towards the whole world if he owes no duty to them. There must be a breach of this duty. The exact breach must have caused the damage. The harm must be foreseeable. In Pertil-Vatloan UDC it was stated, when the danger is reasonably foreseeable, the duty to take care to avoid injury to those who are proximate, when their proximity is known, is based upon the duty that one man has to those in proximity to him to take reasonable care that they are not injured by his acts. Legal claims process. The first step of the process, in our view, is to attend with a solicitor for legal advice. Once the facts are ascertained, a legal opinion on the case will be provided with the law having been assessed in the context of the facts. Should a case commence, it proceeds to the Injuries Board, which is a statutory body tasked with dealing with personal injury claims. Under Section 8 of the Civil Liability Act 2004, this is called a letter of claim. A person pursuing an action should serve notice in writing to the other person within 1 month of the date of the accident of their intention to pursue this course of action. If you have been injured due to the negligence of another and wish to pursue an action to recover damages, you must begin this action within 2 years of the accident date in question. This is a strict legislative rule which has some exceptions for exceptional circumstances. The rule is specified in the Statute of Limitations Act, as amended. Once the cycling accident claim is presented to the Injuries Board, and if the respondent driver allegedly culpable consents to the Injuries Board assessment, the Board will make an assessment, which is a figure of compensation. Damages can include medical expenses, loss of earnings present and possibly future, damages for belongings, and for pain and suffering. The judicial guidelines established under Section 18 of the 2019 Act, which catalogue the level of damages for this type of matter which can be awarded. At this point, if both of you, the injured party and party at fault, agree to the amount of compensation, your case is concluded and the responsible party will be directed to pay the sum awarded to you. If the party responsible or their insurer does not agree to the Injuries Board assessing the claim, then the Injuries Board will not make an assessment decision in the matter. Court process. If both parties concerned in the case don't agree on Injuries Board assessment, or the Injuries Board do not assess the matter, then the matter may need to proceed to court. Drivers must pay compulsory insurance cover in Ireland. Sometimes the driver does not have insurance, and in this circumstance compensation for victims of uninsured drivers is tasked to the Motor Insurers Bureau of Ireland. We assist clients with cases from the start to finish, preparing and submitting the PIAB application, gathering evidence and expert reports, representing our client in court if necessary, and dealing with any negotiations. If you have any questions, our contact details are 01 54611121 or 052 612 1999, or our email address is info@clearysolicitors.com, personal injuries. In contentious business, a solicitor may not calculate fees or other charges as a percentage or proportion of any award or settlement, or